Ros, this is a message from Michael Ryland, a commissioner back in the mid-90s. Thank you for the opportunity to contribute to the 40th anniversary of the Australian Law Reform Commission, and let me start by congratulating the Commission on its first 40 years. It amazes me that it is 40 years already. It seems not so long ago that I was at the celebrations for the Commission's 20th anniversary. 20 years ago, we celebrated that anniversary with a conference in Canberra, opened by a young comedian playing a violin as part of his routine, and with a dinner on the harbour side of the Sydney Opera House. There was a light breeze that Sydney night that billowed through the marquee and made us feel like we were sailing to Kirribilli House. Les Murray read us poems lamenting banks evicting farmers. Then as now, shortcomings in the financial system were a topic for reform. These were not only celebrations, they were also experiments, stretching our own envelope as a law reform institution on how we could engage with the Australian community. It was a time when the Commission was experimenting, but then I guess, is there ever a time when the Commission is not experimenting? One of the enduring themes of the Commission has been its focus on public consultation, and I think one of the most significant contributions we made 20 years ago was to keep that flame burning by experimenting with new ways of getting people involved and engaged with law reform. We used, of course, all the tried and true techniques of public meetings and discussion papers. We sped the process up with a faster turnaround of consultation and discussion papers leading to the report, aiming at no more than 12 to 18 months between receiving the reference from the Attorney-General and delivering the report. The Reform magazine became a flagship for our work, larger and glossier and claiming a place in the stable of international publications on law reform. We made our papers and reports more user-friendly with executive summaries and even cartoons. Then there were the expert groups. We brought one together to discuss the legal policy implications of this terribly new thing called the information superhighway, which is now more mundanely known as the internet. Another set of expert groups was consulted on the legal policy issues around cross-border civil remedies, which we gave the sexy title of Legal Risk in International Transactions, resonating, I'm sure, with the insolvency and international trade aficionados. The idea that there should be real and considered consultation on laws before they are made or changed, and that the consultation should be with the community as a whole and not just with other lawyers and industry, is now a routine, yes of course, standard to which our lawmakers are held. The Commission, I think, can take some credit for this, and I like to think that 20 years ago we made our own contribution. 20 years later, what are the challenges for law reform now? I think the technology and global drivers are even stronger than they were before. We had an inkling 20 years ago that the internet would test our laws on privacy and defamation, but we did not really foresee how smartphones and social media would so deeply reshape the way we live, how the technology would redefine our patterns and customs of things like employment, of consumer finance, travel, accommodation, almost every facet of life. Our laws need to adjust to now a workforce that is casual, part-time, sometimes working from home, far less unionised. Have we really thought through the consumer protections needed when we pay by flashing our smartphone at a vendor? Do our licensing and regulatory arrangements make sense when we travel by Uber taxis and stay at Airbnb accommodation? The global driver has exposed weaknesses in our ability to inform our public and political debate with reasoned and tested legal policy. We've embraced with excitement the commercial opportunities, but we're not at all sure how to balance free trade with fair and effective tax policies or foreign investment rules. We're keen to travel widely and to be tourists and citizens of the world, but we've made a complete hash of our own policies on the international movement of people when it touches our own shores. We've reacted with blunt legal instruments to the challenges of asylum seekers and national security issues, progressively removing well-established and tested legal rights and protections without a coherent or considered legal policy framework. The outcomes have been distressing, tragic and divisive. Some of the law reform challenge is keeping our legal infrastructure in good repair, making sure that the legal pathways for all these incidents of personal, commercial, national and international life are clear and work. Good fences make good neighbours. But the special task and challenge for law reform is to make sure that the legal infrastructure always incorporates and reflects the legal policies that promote substantive and procedural justice. On this, I'm a conservative. I like the well-established legal policies of natural justice and independent judiciaries and protecting an individual's rights and not having retrospective laws creating crimes and all of the other attributes of the rule of law, because they've been tested and they work. I think one of the biggest challenges for law reform in Australia today is to remind people of that and to keep on reminding them. Congratulations, Commission. Keep up the good work. If the intergenerational report is right, I should still be here in 40 years' time, and I look forward to congratulating you again then.